Agent or distributor, which should I use? Today, I want to explore a practical but often misunderstood question. When expanding into a new market, should I use an agent or a distributor? Although the terms agent and distributor are often used interchangeably in the commercial world, there is a clear legal distinction between them. That distinction matters because it shapes the supplier's control, its risks, its ability to enforce terms, and the costs of ending the relationship. What I'll do today is explain the difference between agents and distributors, show why a supplier might prefer one structure over the other, touch on competition law and vertical agreements, examine exclusivity, non-compete restrictions, and good faith obligations, and finally, discuss what happens when things come to an end. By the end, I hope you'll see that there isn't a one-size-fits-all answer, but you will have a clear framework for making the right choice for your business. What is an agent? In strict legal terms, an agent is someone who acts on behalf of another, the supplier, often called the principal, in creating binding contractual obligations. Depending on the agreement, the agent may have authority to conclude contracts directly on the supplier's behalf. The contract is always between the supplier and the end customer, with the agent acting only as intermediary. The supplier sets the price and other terms of supply to the customer, and the agent has no contractual liability for performance. The supplier bears the risk of bad debts if the customer doesn't pay, and the agent's remuneration is usually commission, calculated as a percentage of sales. In other words, the agent provides a service to the supplier rather than reselling goods. What is a distributor? A distributor, by contrast, is a business that buys goods from the supplier and resells them in its own name, on its own account. The distributor has no authority to bind the supplier contractually. There are always two contracts, one from the supplier to the distributor and one from the distributor to the customer. The supplier typically has no direct contractual link with the customer. Local law may even prohibit the supplier from dictating resale prices. The distributor bears the risk of bad debts from customers, though the supplier's risk is channeled into a single debtor, the distributor itself. The distributor earns money from the margin between the purchase price and the resale price. So, in contrast to an agent, the distributor is effectively a customer of the supplier. Why does the distinction matter? Well, a supplier should decide at the outset which model best suits its objectives. If the supplier wants maximum control over prices, customer terms, and brand positioning, then an agency relationship may be preferable. If the supplier wants simplicity and insulation from customer risk, then distributorship may be more attractive. There are also important legal consequences. In Great Britain, the commercial agents regulations apply to agents, but not distributors. These regulations provide valuable protections for agents, especially when their agreement is terminated, which can significantly affect a supplier's costs and flexibility. Agency and distribution agreements are both forms of vertical agreements, arrangements between businesses at different levels of the supply chain. For example, a supplier and its distributor, or a principal and its agent. Under both UK and EU law, vertical agreements attract competition law scrutiny. Agreements that fix resale prices, share markets, or restrict sales are often unlawful. For agents, the risks are lower. Because the supplier sells directly to the customer, the supplier can lawfully fix customer prices. For distributors, the law is stricter. A supplier usually cannot dictate the resale price, except in limited circumstances, such as recommended or maximum prices. This distinction is important. If maintaining consistent pricing in the market is critical, agency is often the better structure. Both types of agreement raise the issue of good faith. In agency agreements, the commercial agents regulations expressly require both the principal and the agent to act dutifully and in good faith. In distributorship agreements, there is no equivalent statute. However, courts sometimes imply a duty of good faith, into what they call relational contracts, long-term arrangements built on trust and cooperation. Examples of commercially unacceptable conduct for both types of relationship include deliberately withholding information that affects sales, diverting customers to a competitor, refusing to cooperate with the agreed marketing efforts, and acting dishonestly to undermine the shared purpose of the agreement. Suppliers also need to decide whether the agent or distributor will be exclusive, sole, or non-exclusive. In exclusive agreements, only the appointed agent or distributor can sell in the defined territory. Even the supplier cannot do so directly. In sole agreements, the agent or distributor is the only authorized third party in the territory, but the supplier can still sell directly itself. In non-exclusive agreements, the supplier can appoint multiple agents or distributors in the same territory. Poor drafting here can cause costly disputes. For suppliers, non-exclusive or sole arrangements provide more flexibility. But exclusivity may be needed to incentivize a partner to invest in marketing and infrastructure. Perhaps the most critical difference between agents and distributors comes at the end of the relationship. Agents are protected by the commercial agents regulations, and unless the agreement specifies indemnity, the agent will automatically be entitled to compensation. Compensation is assessed by reference to the value of the agency to a notional third-party purchaser at the time of termination. Indemnity is capped at the average annual commission of the preceding 5 years. It requires that the agent has brought in new customers or increased business from existing ones, and that the supplier continues to benefit from those customers after termination. Distributors have no such statutory rights, and unless the agreement itself provides for compensation or stock buyback, the distributor has little protection. One of the strongest arguments in favour of agency is commercial control. With an agent, the supplier decides pricing, payment terms, and conditions of supply. With a distributor, the supplier relinquishes that control. The distributor decides resale terms. Suppliers that price control luxury brands, for example, often prefer agency. Suppliers that value reach and insulation from customer credit risk may lean towards distribution. There are some other risk areas to be aware of. Both types of relationships can include non-compete restrictions, the enforceability of which depends on reasonableness and equality of bargaining power. Both types of relationships include a degree of supply chain liability. All parties risk criminal liability if goods are made with forced labour or in breach of environmental standards. With regard to intellectual property, distributors often use the supplier's trademarks and branding extensively, despite the supplier having less control over how their IP is used. Therefore, when appointing a distributor, it is critical that a supplier sets boundaries as to how its IP shall be used. So, agent or distributor. Agents give the supplier direct customer contracts, strong control over pricing and brand, but also expose it to statutory obligations, including compensation on termination. Distributors insulate the supplier from customer credit risk and avoid statutory compensation rights, but at the cost of control. The choice depends on what the supplier values most: control and brand consistency, or simplicity and risk management.